All right, guys, welcome back for section 6.2. Today we're going to be talking about the Fourth Amendment and the warrant requirement of the Fourth Amendment, right? So I don't have the text in front of me, but essentially the Fourth Amendment to the United States Constitution says that people shall be secure in their persons, houses, papers, and effects from unreasonable searches and seizures, right? Now, what exactly that means has changed a lot. And in the next subsection, we're going to be talking all about the court cases that have changed exactly how that's interpreted. But essentially, the important bits are police can't have an unreasonable search unless they have a search warrant. Okay? Now, a search warrant is what happens is that a police officer or a detective or somebody that works for that police department is going to fill out this really long form. And it essentially says, this is what I want to search, this is why I want to search it, and this is what I'm looking for. Okay? So let's say there's a stolen motorcycle, right? I believe Billy Bob stole it. So I'm going to search Billy Bob's house. Here is his address. Here is a photo of his house from the curb. This is a description of the house. So you have to be very, very specific. As more information, the better. You don't just put down the address. You put a picture if you can. You put a description. It's a red brick house with a white picket fence, and it's got a detached garage on the west side, and all those things. Plus the street address. Then you put, this is what I'm looking for. I'm looking for a 2008 Kawasaki motorcycle model, blah, 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 that was stolen from such and such person on such and such a date and such a time. Then you put why you think it's there. An undercover police officer heard Billy Bob say that he was the one that stole it and he's storing it in his garage and blah, 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 right? And these end up being these very long documents describing exactly where they want to search, what they're searching for, and what their probable cause, remember that word from earlier sections? What their probable cause is to believe that that thing can be found in that place. That document then goes before a judge, right? It can be a state judge, federal judge, whatever. And the judge will look at it and he'll read it, and he or she will say, okay, does it reach the level of probable cause? Do they have enough information in this warrant to make me believe that there is probable cause that that thing is going to be found there? Whether it's drugs, whether it's guns, stolen property, whatever. Does it make sense that they have enough legal authority or enough evidence to believe that that thing is going to be found there? And if the judge is convinced, yep, sounds like there's totally enough probable cause to believe that they will find that thing there, they will sign that warrant. And then once they've signed it, the judge will give them a certain time period, right? So within 7 days after signing, or between December 1st and December 10th, or whatever, the judge will give some time limit. It can be shorter time limit, longer time limit. It can start immediately after signing the search warrant. It can start the next day. It can start whenever. And the police have to serve that search warrant within that time limit. Okay? But not all searches are unreasonable, and thus not all searches require a warrant. There are lots of exceptions. There are lots of times when the police can search even if they don't have a warrant. Okay? Now, the first one on the list is search incident to arrest. Okay, so if the police arrest you, and assuming it's a good arrest, assuming they have the probable cause to arrest you, whether it's because of an arrest warrant, whether it's because you ran from the police, whether it's because whatever, right? They have the legal right to arrest you. That's the assumption here. Once they do that, they get to do a search incident to arrest, in which they search not only you, but all your clothing, if you have a backpack or a bag on you, they can search the backpack or the bag. They can also search anywhere that was in your immediate reach during your arrest, right? So if you were driving a car when they arrested you, they can search essentially the car. If you were In an office, they can search the desk you were sitting at. And anything that was kind of within your reach when they came up and first started their interaction with you that led to your arrest. Okay. The legal reasoning there, the reason why they don't need a warrant for this is because they want to make sure, A, they get to search you and your clothing and things like that to make sure you're not bringing contraband into their jail, right? They don't want drugs or guns or knives or anything else, any other kind of contraband in the jail. So that means they get to search you, your pockets, your clothing, up to and including, if they need to, your bodily orifices, to make sure you're not bringing contraband into their jail. But then they're also searching for stashed evidence, right? So I saw them coming, I took whatever contraband out of my pocket, and I very quickly hid it in the desk, right? The police need to be able to find that, right? So if they caught you hiding under a house, which was on an episode of Cops I watched recently, the police saw this guy hiding under, they were chasing him, he got away, but then they were walking around the neighborhood and they saw him lying under a house. So they were able to get him out from under the house, arrest him, whatever, but then they also can go in and search under that house. And guess what they found? A whole bunch of drugs that the guy had kind of ditched while he was hiding under there. But he also could have ditched a gun, right? So they don't want some kid to come along and find that gun that the guy ditched right before he got arrested, and get in trouble, right? So they're allowed to search essentially you, any bags or clothing on you, and anything within your immediate area when they arrest you. Don't need a warrant. The next thing on the list, this is a very, very interesting legal concept, but very misunderstood concept too. It's called plain view. Okay? Anytime an officer is in a place that he or she is legally allowed to be, and they can just see something, that does not count as a search, thus it does not require a warrant. It is completely outside of the Fourth Amendment, right? So let's say an officer is chasing a suspect, and the suspect is running towards his apartment, and the suspect bursts into his door, and the police officer follows him because he's in hot pursuit, doesn't need a warrant to go into the house, follows him into the apartment, tackles him in the living room, arrests him. As the officer has a legal right to be there, he has not violated any laws, he was chasing a suspect, he is in this house completely legally, and he looks over, and look, there's a kilo of cocaine just sitting on the nightstand. And it looks exactly like a kilo of cocaine. It might, maybe even it's labeled like John's cocaine. That is not a search. Because the police officer was legally allowed to be there, he was perfectly within his rights to see the thing, and thus, plain view, not a search, perfectly okay. Similarly, during a search warrant, let's say we're searching for a stolen motorcycle, right? And we open the door to the garage, and oh man, there's not a stolen motorcycle, but there is a dead body or a kilo of cocaine or a whatever. Even though that's not what we were searching for, we had a legal right to be there because we had a valid search warrant, and we saw evidence of crime. That is plain view. That is not a search. You are perfectly within your rights to arrest them for that, and that is not a violation of their Fourth Amendment rights. Now, any kind of action by the officer can make that a search. So for instance, let's go back to I'm chasing a guy, I tackle him, he goes into his apartment, I tackle him, I handcuff him, I look up, and there on the nightstand is something covered by a white cloth. If I reach out and pick up the cloth and look underneath it, that is a search. No longer plain view. Just the act of lifting up that cloth makes it count as a search, and I needed a warrant to do that. Okay? That is a search. There was a case I read about where a police officer was in somebody's house or in their apartment taking a statement One of the people who lived there was a victim of a crime. I don't remember what they were a victim of. But he was taking their statement, writing all the things down, and while he was there, he looked up, and there was a stereo on the mantle. And he was like, man, we had that exact same model of stereo stolen from a house just down the street like 3 nights ago. I bet that's the stolen stereo. So while the person he was taking a statement from went into another room or something, he walked over to the stereo and he moved it just a little bit so he could see the serial number on the back. And he wrote down the serial number. And then he went and he found out, oh, that's the serial number of the stolen stereo. And he went back and he arrested the people. Well, just the moving of the stereo so he could read the serial number means it's no longer plain view. He needed a warrant. That was a search. He didn't have a warrant to search that stereo or that house or anything in it. It was not plain view. Thus, the evidence is tossed. Okay? Plain view only counts if you literally just look and see and, oh, look, that is obviously some kind of illegal something, right? This also applies to your other senses, okay? So if I have a legal right to pat you down, say, for a weapon, and we'll talk about Terry v. Ohio in the next subsection, but if I'm patting you down for weapon and I feel what is obviously some other kind of contraband, baggie of marijuana, baggie of cocaine, whatever, I can then pull that out of your pocket, and that is not a search. If I had the legal right to pat your clothing down and I feel something that is obviously contraband, does not count as a search. I don't need a warrant. Now, if it's in a container and it's not obviously contraband, it is no longer plain touch, right? So if I pat you down and I feel a glasses case, you know, those little snappy cases that people keep their glasses in, but I know you don't wear glasses. So I take the glasses case out of your pocket, open the glasses case, and oh, look, there's drugs inside. That is a search because it was not plain touch. It was not obviously contraband when I first felt it, okay? Similarly, there's plain smell, right? So obviously, sometimes humans can smell drugs, but more importantly, dogs can smell drugs. And if they can smell it from a place where they have a legal right to be, then it is plain smell. That does not count as a search for purposes of the Fourth Amendment. Thus, you do not need a warrant. Now, by far, the most common exception to the warrant requirement is consent, right? So the police officer says, hey, can I search your backpack? Can I search your car? Do you mind? If the person says, yeah, sure, go ahead, then you don't need a warrant. Right? So if a police officer comes up to me, I'm on campus, I got my backpack, they say, hey, we're looking for a stolen thing, do you mind if I search your backpack? I can be like, yeah, sure, go ahead. And as long as I say, yeah, sure, go ahead, they can search that for whatever they want. And then let's say, but now plain view applies, right? So if they're searching my backpack for one thing, but, oh, look, they found another, because they had consent, they had a legal right to look in the backpack, and thus anything they find, whether it's what they're looking for or something else that is obviously contraband, it falls into plain view, no warrant needed, okay? But the most common, well, I don't know about, the most common exception to the warrant requirement is consent. A lot of times, they're searching the bad guy's stuff. They want to search the bad guy's car, they want to search the bad guy's backpack, whatever. But this also works for the victim of a crime, right? So if my computer gets hacked and somebody steals my credit card numbers, I'm going to call the police and they're going to be like, hey, do you mind if we search your computer for evidence of this crime? And of course I'm going to say yes, because I want them to catch the bad guy so they can search my computer. Thus, they don't need a warrant, right? They have no need for a warrant to search my computer because I'm the victim. I want them to search my computer. I know there's nothing illegal on it. I want them to find evidence of the crime. Please search my computer. Right? So that, yeah, remember, that's the number one biggest, we don't need a warrant situation. Next one, an impounded vehicle, right? So let's say, I pull somebody over, I go up, I ask for their ID, they hand me their ID, and oh, look, this is John Smith. John Smith has an arrest warrant. Oh, I got to arrest you on this arrest warrant. Please come with me. Put him in handcuffs, blah, blah, blah. What do I do with the car? I'm not just going to leave it there on the side of the road, right? So I call a tow truck. Tow truck grabs it. They take it to the police impound lot. Now, for similar reasons as to why I would want to search a person if they're being arrested, I also want to search their car if it's going to go into the impound lot. I want to make sure it doesn't have, a dead body in it, or a bomb, or drugs, or anything that could hurt anybody, or whatever. So the police have the legal right to search any vehicle they impound, right? So they can look in the driver's side, passenger side, the console, anything. There are some exceptions to this. For instance, if they find a safe in the back of the car, they can't open that locked container. But for the most part, they can search essentially the entire vehicle, with some exception. There's a public safety exception to the warrant requirement, right? So like if an apartment building is on fire, and it's like, wow, police need to get everybody out of the building, and we want, it's the middle of the night, we want to make sure everybody's awake, we want to make sure everybody gets out. They're allowed to, say, break down an apartment door, go in, see if there's anybody sleeping in the bedrooms, do a very quick once-over, make sure nobody's about to burn to death, and then, leave. That is a public safety exception. Like, if somebody's in that apartment, they're going to burn to death, they're perfectly allowed to break in and for that purpose, okay? At border or port areas, and this includes airports, there are a lot of exceptions to the warrant requirement, right? So when I want to fly on a commercial plane, the TSA, which is a government agency, are allowed to search my bags without a warrant, right? Because I have lower Fourth Amendment protections at an airport. Similarly, if I try to cross either the Mexico-U.S. border or the Canada-U.S. border, the Border Patrol or whatever government agency is allowed to search my luggage, my car, my whatever, without a warrant, because that is a reasonable search. Thus, for purposes of the Fourth Amendment, and the Supreme Court has ruled that because those border areas and those port areas are used so often for things like bringing in drugs, bringing in guns, bringing in all this illegal contraband, the border agents or agents of the government do not require a warrant to search any of those things. In schools, if I am a child in a public school, I have far lower Fourth Amendment protection, not from the police, but from other government agents like school officials, right? So a school official, i.e. a principal or a vice principal, is allowed to search students without a warrant. They're allowed to search lockers without a warrant, right? Now, what often happens is if a principal or vice principal suspects, little Timmy of dealing drugs at his high school, what the principal can do is call the police and say, hey, I need your help. I think one of my students is dealing drugs. The police will show up. The principal will open Timmy's locker, and he can search through it. And if he finds drugs, all he has to do is make sure it's sitting there in the open and then step back. Now, the police, they have a legal right to be in the school, right? They just look in this open locker, and in plain view, there are drugs. Right? The police don't need a warrant for that because it's in plain view. Now, the principal did the searching, and he is a government agent, but because it's a public school, they have, the agents of the school have increased ability to do searches without violating the Fourth Amendment. So that's kind of a common tactic that's used within schools. There's kind of the catch-all exigent circumstances. Okay, police are allowed to search anything if there are exigent circumstances present, i.e., for some reason there is not enough time to get a warrant, right? So, if the police are standing there and they're knocking on a door of a house and they're like, hey, open up, it's the police, we want to come in, and they hear someone, a woman scream, and, oh my God, he's going to kill me, he's going to kill me, please help me. Do they have time to get a warrant so that they can search that house and go into that house legally? No. Like, if that woman is legitimately in fear for her life, she's legitimately being attacked, police don't have the time to go get a warrant. Thus, that constitutes exigent circumstances. It's an emergency. Police are allowed to bust down that door, make sure that woman's okay. Now, once they've made sure that woman's okay and they look over and, oh, look, dead body on the floor. Plain view. Because they're legally allowed to be in that house because of those exigent circumstances, saving that woman's life. Thus, anything they see in plain view while they are in there and while they are doing that job of saving that woman's life no longer counts as a search, right? And then finally, there's the good faith exception. Officers legitimately thought they were doing the right thing. There was some accident, some mess up with something, and they accidentally got the wrong thing. That doesn't invalidate the search, right? So there's a bag sitting on the floor, somebody standing next to it. Police say, hey, do you mind if I search that bag? Guy says, yeah, sure, go ahead. Police search the bag, find contraband. They believed they had consent. There was a reasonable belief they had consent. But then they find out, oh, the bag doesn't belong to the guy who gave consent. But he didn't say it didn't belong to him. He just said, yes, go ahead and search it. The officers had every reason to believe that they had consent to search it, when in reality, that bag was somebody else's. The person who gave the consent didn't have the legal ability to give consent. The Supreme Court has ruled that because the officers had a good faith belief that they were legally allowed to search that bag, it's okay. That didn't violate anybody's Fourth Amendment right. Just because a warrant accidentally has a typo on it and it has the wrong address, it says 12345 Main Street instead of 12346 Main Street, that does not invalidate the warrant. The officers believed in good faith that they had a warrant to search that premises. Just because there was a typo on the warrant doesn't make it somehow invalid, right? Make sense? Okay, so we're going to come back next time and we're going to talk a lot about court cases that have influenced policing and police officers. See you then.